As a patent attorney with 20 years of experience with the patent examination process, I'm going to give you the insider info on what to expect from the examination process, including how long it takes, why rejections are actually a natural and positive part of the examination process, and how to overcome common rejections and get your patent application allowed. The first thing to understand is that only non-provisional patent applications are actually substantively examined. Provisional patent applications are not examined at all. Okay, so this is a good time to step back and sort of give you a summary of the two ways to start the patent process. One is with what is called a non-provisional patent application. And this is the application that you typically think of that has the formal drawings, the formal description, it has a claims section. That's the one that you file at the United States Patent and Trademark Office. It waits in line for 1 to 3 years before examination begins, which then begins a negotiation with the examiner where the examiner is going to do a prior art search to determine whether what you have claimed is new and non-obvious over the prior art. This back and forth can go on for months, if not years. Hopefully the application is allowed, and then you'll pay an issue fee, and then the application will issue as a patent. So that is the non-provisional patent application. That is one way to start the patent process. But especially for startups and new companies, it's good to start with what is called a provisional patent application. So a provisional patent application, it is just a placeholder. It only lasts for 1 year. It automatically expires the end of the year, and that term cannot be extended. And that's when you have to then file that full non-provisional, which will at some point be examined. So the provisional, like I said, it's just a placeholder. It's not substantively examined. And really the USPTO is going to slap patent pending on really whatever you file as a provisional application. So when I'm talking about the examination process, realize that I'm talking just about non-provisional patent applications. So it may sound crazy, but rejections are actually a natural, positive, and expected part of the examination process. And the first thing to understand about why that is because patents are not just a binary thing, as in you don't just have a patent or you don't. You can have broad patents that cover a lot of different variations, and that the patent is going to be therefore more valuable. Or you can have patents that have claims that are so narrow and so specific that it's almost impossible for somebody to infringe or absurdly easy to design around. So when it comes to the examination process, what you're actually trying to do is you're trying to get the broadest claim scope possible. And just like in any negotiation, it's good to have a back and forth. That's how both parties come to a good negotiation stance where both people get what they need. And so in the examination process, what you're trying to do, like I said, you're trying to get the broadest claims possible, but the examiner needs to make sure that what you have claimed is new and non-obvious over the prior art. And so what we typically do, we set up the examination process so that the claims are probably a little bit broader than what the applicant is really entitled to. And then the examiner will frame the issues, assert prior art rejections, and then that allows us to determine, okay, what are the minimal changes we need to make to the claims to just barely get over that hurdle of patentability so we don't narrow them too much and make them worthless, but so that we still get a patentable application and still get the broadest claims possible. That's what we're really trying to do in the negotiation process of examination. And that's why rejections are a natural and expected part of the process. So if rejections are a natural part of the examination process, what kind of rejections are you going to be getting? So to step back, to get a patent, your claims must be new and non-obvious over the prior art. And what the examiner is going to do when they first pick up the case is they're going to do a prior art search and find either issued patents, pending patent applications that have published, or any other sort of prior art that was a technology disclosure before you filed your patent application, and determine whether what you have in your claims is new and non-obvious over the prior art. So there's a couple of main rejections you're going to see. One is going to be an obviousness rejection, and that is a question of, would it be obvious to one of ordinary skill in the art, that being your average person who works in the field, to come to what you have claimed in your invention based on all of the known prior art out there? And the way it works in practice is the examiner is going to find one piece of prior art and say, well, this has a lot of the elements that are in your claims, but it doesn't have all of them. But if I look to other prior art that's sort of in a similar field, that's related, it would be obvious to add these other elements together and come to your invention. And so that's what an obviousness rejection is. Another one that's fairly common is a novelty rejection. A novelty rejection is just related to a single piece of prior art. And here, the examiner is saying that, hey, I found this one piece of prior art. It can be any sort of prior art. It could be an issued patent, a pending application that's published, a blog post, YouTube video, any sort of technology disclosure, the examiner is going to say that one piece of prior art discloses everything in your claims. And a lot of times, novelty rejections are fairly easy to get over. What you do is you just add additional elements, as I'm going to kind of discuss later, in response to the novelty rejection. And usually then what's going to happen is it's going to turn into an obviousness rejection, because you'll add elements that aren't in the prior art, and then the examiner will say, okay, I'm going to find this maybe in another reference and combine it with the primary reference and turn the 102 novelty rejection into a 35 USC 103 obviousness rejection based on multiple references, probably using the same one that they started the novelty rejection with. So other rejections include lack of support or clarity in the claims. That's 35 USC 112. And that's going to relate to if you don't have support for the claims or if the claims are unclear. Also, you may get some formality rejections related to the drawings or the text, but 99% of the examination process is going to relate to the claims section. So what is this claims section? It is not the description. It is not the drawings. It's this little section at the very end. There's about 20 single sentences that are awkwardly written, that are hard to understand, and those define the metes and bounds of what is actually going to be protected in the patent if it were to grant. And so it's all about a negotiation over these claims, over how broad or narrow they're going to be. It's not really about the drawings or the text. The examiner is going to look at that maybe to interpret the claims, but really it's going to be 98% about this claims section. The claims section is what is the main part of the examination process. So you get these rejections, whether it's a novelty rejection or an obviousness rejection, but how are you going to overcome these rejections? Okay, so there's two things that you can do. One is you can argue against them, and you can amend the claims to differentiate your claims over the prior art. So in terms of arguing, you can argue to the examiner, say, hey, you've misinterpreted our claims. You're saying that these elements are present, but they're really not. That doesn't relate to the prior art in the way that you're saying. Or you can say, hey, examiner, you misinterpreted the prior art. It doesn't teach what you're saying it teaches. It doesn't teach these claim elements that we have. Or you can amend the claims. And what that looks like is adding additional elements that aren't taught by the prior art. And that usually ends up what has to happen in the negotiation process. And that's because we usually set it up so that we have broad claims, and then the examiner throws prior art at you, and you determine what are the minimal elements that you need to add to the claims to get over those prior art rejections. One of the important things to note about claim amendments is you can only include elements that are supported fully by the description and or drawings of the original application. So the original drawings and the original description, those are set in stone. The only thing that you can amend is the claim section, and that has to, whatever amendments you make has to be fully supported by the description and drawings. So what happens? You file a response to what is called an office action. That's where the examiner is going to assert these novelty and obviousness rejections. You file a response, and then it's going to wait another few months. Sometimes it can be upwards of a year, depending on how backlogged they are. And then the examiner is going to do another prior art search, and they're going to look at your updated claims. They're going to look at the arguments and determine whether you've shown to them that what you have claimed is new and non-obvious over the prior art. So what happens a lot is if you've made claim amendments, the examiner may then pull in more prior art and try to say, hey, it's obvious in view of this additional prior art. And you can go back and forth with the examiner multiple times. But hopefully at some point, the examiner will be convinced that what you have is new and non-obvious over the prior art. You've satisfied all the other conditions, and then we'll allow the case. We'll send you what's called a notice of allowance. Then you get 3 months to pay an issue fee, and then the application will grant as a patent. Now, as you can already tell, the patent examination process is really long, especially if you start with a provisional application. So the provisional application, it lasts for 1 year. Then you'll file the non-provisional application at the end of the year. So that's already 1 year. You file the non-provisional, it's going to wait in line for 1 to 3 years before examination begins. And the reason for that is it's just the government. They are behind on things. They are understaffed. So it just takes 1 to 3 years before your application moves up to the top of the line. That's what caused the delay. So there you're already at 2 to 4 years. So then like I said, the examiner is going to do a prior art search to determine whether what you have is new and non-obvious over the prior art, is going to formulate rejections and put them in the form of an office action, which is a written document that is sent to your patent attorney. And once you get this office action, you have 3 months to respond without paying additional fees, but you can extend that to up to 6 months by paying extension of time fees. So there you're coming up, that's gonna be an additional 3 months or so, potentially 6 if you go into extensions. And then it takes the examiner months, if not longer, to then get back to you with another office action. So again, they're gonna do another prior art search, determine whether the claim amendments or arguments have convinced them that what you have claimed is new and non-obvious over the prior art. Then they will send you another office action with new rejections typically. And then again, you have 3 months to 6 months to file a response. And this can go back and forth for a while. Sometimes it goes really fast. It depends on the examiner, depends on the prior art, depends on the case. Sometimes it's really quick. Maybe it's only 1 or 2 office actions. In rare cases, you get a first action allowance where they send out a notice of allowance first. But usually it's gonna be probably 2 to 4 office actions, but sometimes it can be more. You can go back and forth multiple times. You may have to appeal the case. There can be really long delays in the process. But hopefully, like I said, at some point the examiner is convinced that what you have is new and non-obvious over the prior art. They will send you a notice of allowance with such a deadline of 3 months to pay an issue fee. You pay that issue fee, and then typically within 3 to 6 weeks, your patent application will finally issue as a patent. So who are these patent examiners that you go up against at the United States Patent and Trademark Office? And the answer may surprise you. So they're not attorneys, they're not judges, they're just typical folks with a technical background. So patent applications are highly technical documents, and a lot of times they're going to be in fields like physics or computers or biotechnology. So people have specific technical backgrounds, and then they become examiners in what is called an art unit, which is sort of a specialized group of examiners who examine patent applications with a specific type of subject matter. Because just as much as your patent attorney needs to understand the technology that they are patenting for you as well as, if not better than you, the examiners have to understand it really, really well as well. Because otherwise they're not going to be able to understand what the description is. They're not going to be able to interpret the claims. So patent examiners are just folks, a lot of times they're just going to have an undergrad degree in something. A lot of times for things like biotech, people will have maybe a master's or PhD, but a lot of times these are just folks with an undergrad degree. They're not attorneys, they're just regular folks. And a lot of times examiners can be fairly young, especially who are new to the United States Patent and Trademark Office. So when it comes to office actions and these responses, these are all officially written communication. So the examiner has to send out this office action, and then you have to do a written response. Although there is an ability to do interviews with the examiner. It's not totally common, but it's something that can be really helpful to progress the examination process by actually getting the examiner on the phone, talking about the case, and even just asking them, hey, what can we do to get this allowed? So you can have video interviews, you can have phone calls. In very, very rare cases, you'll meet them in person, but I think a lot of examiners don't like to do that. It makes them kind of uncomfortable. So it's better just to do phone calls, because a lot of times it doesn't need to be that involved, the process. A lot of times the interviews that I do, they're really only going to last maybe 5 minutes, half an hour at the very most, if you set things up correctly. So when it comes to examiners, like, what are they like? Are they mean? Are they nice? Well, the reality is obviously it really varies, but examiners are not attorneys, so they're not trying to fight you. Most of them are trying to help you actually get an issued patent, especially if you go about it the right way. And especially in these interviews, you can talk to them like a person, which they are totally people. They are people behind the scenes. Usually they're going to be really great people. And so you can talk to them and say, hey, what do you think about this case? What could we do to get it allowed? Do you see points of novelty? What could we add to the claims? Or what could we even argue to get this allowed? Because most examiners, they're on your side. They want to get the case off their desk. They want to get it allowed, but they need to make sure that what you have is new and non-obvious, because if they let an application get issued that shouldn't, where the claims are too broad, they're going to get in trouble. So really, they want to make sure that they tick the boxes, that what you have is new and non-obvious, that it satisfies the other conditions, but otherwise they usually want to give you a patent. There are sometimes those examiners who somehow think that their job is to stop things from being patented, or they don't like certain inventions, and that can be difficult. But most folks, they are not argumentative, they're not confrontational, and especially if you don't come at them that way. So as someone who's been working with patents for over 20 years, I want to give you sort of my inside view of the examination process and things that are kind of surprising or big takeaways that you should have about the examination process. And one is that it's very subjective and it varies from examiner to examiner. Some examiners they're going to find prior art and say, well, I see your claims that, they're different. And so I'm going to let you get a really broad patent and I'm going to give it to you really fast. There's not going to be much examination. They're going to want to negotiate and wheel and deal. And they're going to use the interviews to be able to get to claim amendments fast. They're going to get you to allowance quickly. Others are going to be difficult. They're going to find prior art and say, well, this is all just obvious. You could take these 10 references and combine them all, and then it would come to your invention. And so I'm not going to give you a patent, or if I am, it's going to be so narrow that it's almost going to be worthless. And then you have to kind of go back and forth and back and forth. And sometimes you get examiners, especially new ones, who don't understand the technology or don't understand the law. That can be really difficult in a lot of ways, because you kind of have to teach them, hey, this is what the law is. Like, you can't make rejections in this way. That's improper. Or, well, this is what the technology is. Like, this is what our invention is. That you're kind of completely misunderstanding what's going on here. And it's fair. I give examiners a lot of credit. They don't have a lot of time to do the examination. So it's pretty easy a lot of times to kind of miss what's going on. And unfortunately, some of them have the incentive just to throw out bad rejections because they don't have sufficient time to really get up to speed on the case, and then sort of make you explain what's going on and use that back and forth time just to kind of get up to speed and learn what the case is all about and learn what the invention is. Another thing to understand about the examination process is that the goal is not just to get a patent. A lot of people think, well, I just want to get a patent. But like I said before, patents are not a binary thing. It's not just having a patent or not. You want to have a patent, but you also want to have one that is as broad as possible. It doesn't need to be absurdly broad, but it needs to be broad so it at least covers your technology and covers in a way so that people can't easily make changes to what your product is and design around it, because otherwise your patent is going to be worthless. You obviously want to have something that covers your product, but you also want to have a patent that covers the technology in a wide variety such that people can't just make easy changes to it and then design around it and not be infringing your patent. So another thing to consider is don't take rejections personally. It's a natural part of the process. And a lot of people will say, oh, the examiner doesn't understand. And a lot of times, it may seem like these are bad rejections, but if you look at the claims are really broad. And so the rejections aren't really bad. People will say, oh, well, this isn't what my invention is at all. This is nothing like my invention. But if anything, that shows how broad the claims are, or how broad they could be. And that's actually a positive thing. So it obviously covers a lot of different variations, but in that current iteration, it may cover so many variations that the prior art actually reads on some of those variations. So that's what's going on in examination. Don't take it personally. It's a natural part of the process. Most examiners are there to help you, and you should be fine in the long run.